as Chevron deference. And Gary is going to give us the view from 30,000 feet. What in the world did Chevron deference mean, and what did the Supreme Court do to it?
Well, John, in order to understand this, I want to give you a little bit of history. So if we go all the way back to the Constitution, funny place to begin, but that's where we should begin.
Yeah.
The first substantive provision of the United States Constitution, Article 1, Section 1, says all legislative powers herein granted are granted to a Congress consisting of a House of Representatives and a Senate. So, in theory, all the laws should be passed by Congress. And for about 100 years, that's how the government operated. And then in the progressive era, starting in 1877, the progressives convinced the government that they should create a regulatory agency because the railroads were too powerful. So they created the Interstate Commerce Commission. And following that, various other regulatory agencies were created. And after 59 years, Congress passed in what's called the Administrative Procedures Act. And basically, one of the important provisions of the Administrative Procedures Act was to say that if anyone has a challenge related to regulations that are created by an agency, that they can take the agency to court. And the courts were supposed to interpret the law under which the agency was created. And we went along that way until 1984 in the Chevron case. The Supreme Court created this doctrine. Basically, they said that the courts should give deference to the interpretation of the law that Congress had passed, that they should defer to the federal agency's interpretation of the law. Well, many times when laws are passed, there are ambiguities because people in Congress are fighting on both sides, and so they pass some kind of ambiguous statute that's not really fully satisfying to either side. And the agencies simply take that ambiguity and used it to extend their power vastly beyond what it really should have been, or whether it should have been existed at all, but they extended it a great deal. It's like giving little kids ice cream and telling them they can decide for themselves how much to eat. And so that doctrine prevailed for 40 years, literally, until the Supreme Court in the decision Loper Bright Enterprises versus Raimondo said, hey, you know what? The interpretation of the statutes is really the provision of the courts, and the courts should make an independent judgment about regulatory powers and not defer to the agencies. Really a recognition that the agency's tendency is to just be expansive of the power. And so this is really a great step for liberty to begin to rein in this idea that the agencies can just decide for themselves what the rules should be and that they should make them.
Well, that's a pretty good overview, Gary. Viewers, if you're watching live on Facebook or YouTube, you can add your own comment or question. And Ken's main job here is A, to look pretty, and B, to read your comments and bring up appropriate ones as much as he can. Okay, Dale, you want to comment on this Chevron deference decision?
Yes, I wanted to kick in on this one. I can remember back in my days when I was doing town hall meetings for COS. One of the things that we would present was the concept of tyranny. And that is when we have, and it's all part of our administrative state, basically, where we have agencies that make the regulations, execute the regulations, police the regulations, and adjudicate any punishment for violating the regulations. So that's what this decision, I think, is puts an end to, because what you've got there is you've got tyranny. You've got one part of the government controlling the whole process.
Yeah,
and that's what this is about. So I think this was a wonderful move by the Supreme Court.
Yes, indeed. And instead of three separate branches of government, legislative, executive, and judicial, you've got a lot of that rolled into unelected and unaccountable bureaucrats in the deep state. And the Supreme Court brought an end to that, just brought an end to it. And it's just such a wonderful win for liberty. Charles, did I see your hand up? Do you have a comment to make about this?
Yeah, on that last note, Gary, how did this come about? How did this come back up for any kind of alteration?
Well, the Supreme Court, this doctrine has come under criticism in the last, I don't know, probably since it was first enacted. And this Supreme Court, which is, frankly, the Trump court, with the 3 justices that he appointed, a more conservative bent, they started looking at considering cases were being appealed that would bring up this specific issue and give the court the opportunity to overrule this doctrine. And so that's what they did. They picked a case that said, this is a case that we can look at and say, should we overturn this doctrine or should we sustain it? And thankfully, they overturned the doctrine and opened up a whole new chapter in the relationship of administrative law to the rights of we the people.
Okay, because obviously there are some notoriously bad Supreme Court decisions, but this one sounds massive. Turning this back might be the most, Dred Scott, horrible, horrific, but this sounds like this might be the most important ever.
I don't know if it's the most important ever, but it is a huge win for liberty. It's going to take many more cases in which this is going to be fleshed out more. But the big thing is they said that the courts should interpret the law, not the administrative agencies. And so all those regulations are still on the books, and it's going to be up to individuals and businesses that are being having their rights undermined by regulations that Congress never passed, that will have the opportunity to take these to court and have the courts interpret the statute rather than letting the agencies interpret them for themselves.
Yeah, that's big. That is really big. And one of my pipe dreams is that Congress might finally get its act together someday and start writing specific laws rather than ambiguous laws. But given our political divisions between the two parties, I don't look for that to happen anytime soon, but you never know. You never know what may happen. We got a very pleasant surprise with this. Debbie, do you have any comment or question that you want to make on this Chevron deference before we move ahead to another case?
Yeah, I was just going to make that comment. It sounded like in the lower courts, they had used this. It's like 77% of the time in this administrative law area, they had used the Chevron case. So it's going to be very interesting on future cases how much impact this change is going to have.
Yep. It'll be something interesting to watch. Thanks, Debbie. Dale.
John, you said something about ambiguous regulations. Do you think ambiguity is something that's used as a means of getting something done or compromise, I guess is the term I'm trying to say, rather than being specific?
Well, I think that's part of it. And Gary mentioned that when he gave the overview of Chevron deference, when he said, the two sides couldn't agree on everything. So they compromised and they came up with something that nobody really wanted, but it was the best they could do. I'm paraphrasing Gary. I think that was part of it. And I think another part of it is maybe lawmakers are just lazy or they're overworked or something. And they just haven't been writing specific laws. They've been writing these ambiguities. Yeah. So, okay.
Plugging this into
if you think about it, this has been going on for.
Sorry, go ahead, Gary.
Gary?
I was going to say this has been going on. The Chevron doctrine was 40 years ago. Yeah. And these things were going on even before that, where the agencies were, writing regulations that, they thought were valid from their point of view. And so really Congress is going to have to go back to square one on all of these regulatory agencies, I think, and re-examine those statutes and clarify what the role is of the agencies with respect to, writing regulations.
Yes, indeed. Well, the clock is moving along, and I think we'd better turn the page and go to the second case that we're going to look at. And it concerns many, but not all by a long shot, but many of the January 6th defendants. Dale, give us the picture on that one.
All right, this pertains to a case called Fisher versus the United States, where a gentleman by the name of Joseph Fisher, in this case, was accused of, he was punished under an act called the Sarbanes-Oxley Act from 2002. And if you recall, the act came about from Enron, from the Enron case back in those days, where I believe it was accountants for the company of Enron were in the process of destroying documents that could be used against them, and they were shredding or destroying documents. So that led to this Sarbanes-Oxley Act, where obviously it's illegal to do that. Well, this was amongst the different charges. There were other charges brought against Joseph Fisher as part of January 6th. But part of the charges that were brought against him was in violation of the Sarbanes-Oxley Act. Well, it so happens that Mr. Fisher, of course, didn't have access to any documents, didn't touch any documents. As a matter of fact, according to the timeline, he was only in the Capitol building for 4 minutes. But he was charged, along with many others, under this act, in addition, of course, to other charges. So he appealed his case, and even the appellate court upheld the conviction. So it went to the Supreme Court, and the Supreme Court came down on a ruling 6-3 that that this could not be applied because the defendant would have literally had to impair a physical document, would actually have to destroy a physical document, which he did not do. So this is a ruling in favor of him on this particular charge. Now, are there others that could benefit from this? Other J6ers that could benefit from this? There's possibly about 250, they estimate. Others could benefit from this decision as well. I guess we'll have to see how that happens, or how that pans out. But that's basically what this is all about.
Okay, Dale, you say he was actually in the Capitol about 4 minutes.
About 4 minutes. Now,
and do you have information on what he actually did while he was in the Capitol?
No, I don't. But it was, there weren't any legislators around. I mean, it was kind of later on in what was happening at the Capitol. But no, I don't.
Well, okay, I didn't know if you had that information or not. I just was curious. But there obviously were some of those people who were destructive of property in the Capitol, and somebody went in, the speaker's office and ransacked it and put his boots up on the desk, and that's disrespectful. But so many of the people in the videos that I saw were just walking through the Capitol and taking selfies, taking pictures in Statuary Hall, and I've done that, but not on January 6th. Okay, I was not there, so I hope the feds don't come and slap the handcuffs on me. But anyway, I'm just wondering if maybe he was one of those who was just physically present and just looking around, and they caught his face on a video camera, and they arrested him and
Yeah,
charged him and convicted him.
That's how I
So-
interpreted this. Now,
So
he did stand outside, and he did say some things, about doing terrible things, but he did not. He was not involved in any documents in any way.
yeah, I don't condone bad speech, but it is allowed under the First Amendment. Yeah.
Right. Right.
So Dale, how is this a win for liberty?
Well, I think this is an example of, once again, a piece of legislation or an act being the government overreaching, going beyond its legal bounds.
Yep.
And I think this is a good example of what COS is trying to get at, is to
Yep.
rein in the overreach and control of the federal government.
So there was this law that was passed in the wake of the Enron scandal,
Right.
and the DOJ took that law and applied it in a situation where it was inappropriate,
Right.
and
Right.
that was slapped down,
Right.
summarily slapped down by a strong majority, 6-3.
6-3.
Yeah. Yeah. So okay, well, Charles or Gary or Debbie, any of you have any comments on this one, or any questions for Dale? Debbie?
Well, yeah, I was just kind of reading up on the case too, and it talked about how because of this ruling, it could affect up to 250 more of those people because they were in that same boat as Fisher was. So it'll be interesting to see how that pans out. I'm not exactly sure about next steps on that. I don't know if Dale knows about that or anybody else does.
Well,
Yeah,
next
no,
steps.
I don't. No, I don't know anything.
Okay, maybe Gary can have that, but Gary had his hand up for making a comment.
Yeah, I just wanted to comment that this is really a great example of how federal prosecutors, and it's really done the same thing at the state level, will throw the book at somebody and use statutes that really were not intended to be used in the situation that they're applying them, and prosecute people under statutes. And really, the courts should throw out these charges, but they don't. And what the Supreme Court really kind of said here is, hey, look, when there are charges filed that really are not appropriate for a case, the judge should dismiss those charges. It shouldn't have to go through an appeal all the way to the Supreme Court to get those charges thrown out. A trial court should throw those charges out and focus on the charges that may actually be relevant to the intent of the statute and the actions of a defendant.
Yes, indeed. So Gary, do you have any insight on what next steps might be for these maybe 250 other defendants? Will they have to file for appeals, or does the Supreme Court action automatically? Go ahead, Gary.
I think they can all go back to the trial court and ask to have their case reopened and have that particular charge against them dismissed. Most of them were probably charged under multiple things, so that may not get anybody out of jail, but it'll get something off of their record that says they were convicted of, this charge in addition to whatever else that they may have, had the book thrown at them on.
Yeah.
And so it's a win for them.
Good. Debbie, I saw your hand.
Yeah, I was going to say they now have to demonstrate an evidence tampering related motive. Now they have to prove that they had that motive, which is really going to help quite a bit.
Do you know how hard it is to prove motive?
I hear you. Yep.
You have to get inside somebody's head and know what they were thinking.
Yes.
Yeah. Charles, any comments on this one?
I don't. I'm glad Liberty was served.
Okay.
That's about it.
Now, 250
I mean, the whole
people.
January 6th thing is just it's all a big show.
Yeah. So
It just makes sense that they would just grab something. I don't know, just find a crime to just throw at them, just so we can just paint this narrative that it was this giant organized insurrection. I mean, just all the facts add up to it just being theater.
Oh yeah,
So.
yeah. And underlying what Charles just said is the reality that to my knowledge, none of the January 6th defendants were charged with insurrection. They were charged with all these other things. And so every time I hear somebody say insurrection on January 6th, I'm thinking, what nonsense, you know, nonsense.
Mostly peaceful insurrection.
Hey, that sounds like a good term. Yeah, you coined a term. Dale, you had another thought.
Just I'm gonna speak on this a little bit later in our roundtable tonight, but coming up on July 29th, we've got an interview on COS Indiana Live with an actual J6 prisoner, a young man that's in prison right now. And I've already asked him if this Supreme Court decision will affect him in any way, and he says it won't have any effect on his particular case.
So he was charged on other statutes, other than this one. Okay.
Yes.
Okay, so, Ken, you've been quiet. Anything from the viewing public?
Not really. Just a couple of comments talking about how and this might not be this specific topic, but need to stop working for lobbyists and private interest groups. Our friend David says that people they need to start working for we the people. So just comments talking particularly about how people are not being served at this point.
Yeah, good general comments. Yeah. Well, I'm a little surprised. I thought when we got into 4 big wins for liberty at SCOTUS, I thought we'd get more from the viewing public. Debbie, you're up.
Well, I was just going to say, our justice system works both ways, but one of the things is you can just unfairly slap a lawsuit on somebody when there's absolutely nothing going on, and they have to go through this whole thing, this whole proceedings. They have to follow the law on this. But if you have judges who are bent a certain way, they can actually take something that has no weight behind it and go ahead and drag you through until you finally get to a level where somebody is not on that bent and steps in and says, hey, this is off. Mm-hmm. This needs to stop. We're going to dismiss, or we're going to rule and send you back, or we're going to rule and be done. And all of these seem to be, most of these cases, and we're going to get into Trump here in a little bit, but just so much of everything is just slap whatever you can on him. I wish there were some way to evaluate that. Like, what are the charges on this person? That's what the first court's supposed to do, right? That lower court.
Okay. Yeah, we really need to get back to being a nation of laws rather than some of the shenanigans that have been going on in recent years. We really need to get back to that. Well, again, the clock is moving, and I want us to take a little break now, and we're going to watch a video called We Are COS. Let's play that video.
Something that I could get involved with that can, and in my opinion, will make a difference. And quite frankly, I got tired of yelling at the TV and posting on Facebook.
I just wanted something that I could do that gave me purpose besides just complaining. And so this is something that we're doing to educate and inform all the people around us.
Somewhat reluctantly, I was never I might be classified as a non-voter most of my life until recently.
I'm Mark Peterson. Did 20 years in the military, married, I have 5 grandchildren, 4 children. I was always interested in what I could possibly do in a volunteer mode.
My name's Vicki Buckley. I'm a former makeup artist and a former special ed teacher, and I'm a volunteer with Convention of States. And the reason I'm a volunteer is that I got sick and tired of what was happening to our culture, and it was scaring me because I have 4 grandsons, and I did not like where it was going. Kids don't know their civics, they don't know their history. And Convention of States is a nonprofit, nonpartisan organization that supports the Article 5 Convention.
My name is Chuck Conley. I'm a concerned grandfather, entrepreneur, and always been a hard worker. And sitting on the beach, trying to be retired, I came across from my neighbor, Convention of States. I started to look into the situation of things going on where I live and decided that I should be involved.
Convention of States, the only legal, constitutional, non-military way to get power back to the people.
We need to call a Convention of States And according to Article 5 of the Constitution, that's just what we have a right to do in this country. If 34 states agree, through the legislative process, we can call a convention of states.
During the original Constitutional Convention, all the delegates were there and they were ready to ratify the U.S. Constitution until George Mason stood up and said, hey guys, we forgot something. We gave all the power to the U.S. Congress to call for amendments to the Constitution, but we didn't give those same rights to the states. So at that point, George Mason introduced the Article 5 provision allowing the states to call for a convention. And no one at the convention disagreed with it. It was immediately ratified. And it was put there specifically for what's happening today.
Our founders were brilliant. They thought, what if our government becomes the bully, like England was? How do we reel it back in? And Article 5 in the Constitution says, when 34 states get together and agree to have a convention, then they can get together, propose amendments, create them, and then send them out to 38 states to ratify. Congress is not the only one who can make amendments. And the feds don't want you to know that because they have all the power right now. And to get power back to the people, we need a convention of states.
The Convention of States has adopted 3 pillars to go to the convention with. The first pillar, we want to put restrictions on federal spending. God knows we got $33 trillion in debt.
We need to know where our money's going. Do you know how much money they don't even know where it is?
How can any organization operate without a balanced budget?
Number 2, and this is very broad reaching, is to limitations on federal overreach. We did not allow in our Constitution for a Department of Education, a Department of Transportation, a Department of whatever you want. We didn't vote for that. These are appointed departments within the executive branch, within other branches of government, that we had no say. And those are the ones that are dictating your life.
We can do it ourselves. Just like our forefathers, we can govern ourselves. We don't need the nanny state to tell us how to act, be, and where to be, and to sit on our couch and pay us to stay home and what have you. We can get our own jobs, we can be educated, and we can be self-empowered. And that's how our forefathers intended it, and that's what I would like us to come back to.
And finally is to introduce term limits. Term limits to everyone.
We need term limits.
We shouldn't have representatives be there for 50 years. This is not a lifelong career.
So those are the 3 avenues that we have to talk about in the Convention of States. So it doesn't get sidetracked by a lot of other possible amendments. We'll propose amendments around those 3 topics only.
It's not about left or right, it's about the people. It's about having representation, it's about spending our money wisely, and it's about letting us make decisions at the state level.
It doesn't matter if you're Democrat or Republican. It's just common sense.
I don't even need to explain to everyone what's going on. This is just common sense. Everyone knows that our country is on the verge of collapse. It really is.
And we can see what's going on around the country, that it needs people to stand up, speak up, show up, and make a difference in their communities. It has to start there. And my objective is to do that in my community, and then let it progress to the rest of the state and the other states around the country.
This is the time. This is maybe your last chance. We've got 19 states. We need 15 more. We can get there. We can get 50 states together talking about how we can fix our country. Think about that for a second. 50 different states. And each state gets only 1 vote. That's it. We need 38 states, and we can ratify amendments to the Constitution without the U.S. federal Congress.
If you want to have a purpose, if you want to save your country, if you don't want to say there's nothing I can do and then just give up, then be active. Action is the best thing you can do.
And I don't care whether you're 16-year-old or 106. It's your duty. You're a patriot if you get on board with this. It's simple. It's saving the country, bringing back states' rights, and giving us the authority to dictate our future.
You know, your grandfather died for you, or your father died for you in World War II, and now you're not even going to try to save the country?
We need people to step up, show up, speak up, You can start by signing our petition, which will go to your legislators in every district in the country, and show them your support. From there, we look for volunteer activists, and that's even better. Take our survey, become a volunteer activist with Convention of States.
Convention of States.
Convention of States.
Convention of States.
Just come, get plugged in, and know there is hope.
Wow, what a great message. If I hadn't already signed the petition, that would get me to sign it. Ken, what do you have?
Yeah, John, before we pick up where we left off, we got a couple of comments, which I want to start off with one from our state director, Dale Tipton. He says, all these rulings point out the importance of the president and his power to select Constitution-based justices.
That's great. Yes, indeed.
The other comment comes from David Todd,
Yes.
which kind of kicks right in on the education thing that was being talked about there. And David says, well, the school system needs, or at least children need to be educated that they are the government because they are governed all those rights not listed in the Constitution, and they are retained by the people. So David kind of chimed in on the education side of things.
Mm-hmm.
We certainly know that our Department of Education is one of those things that it is direct overreach from our government.
Oh, yeah. Yeah. And they bribe states and local school districts with money. They say, if you do what we want, here's some dough. Okay. All right. Well, let's move on. Thanks for those two, Dale and David, right, for those comments. Very, very insightful. Let's move on. And Charles is going to talk to us about the third case that we have under consideration tonight. And that is how, get this, the First Amendment rights of the NRA, a Second Amendment organization, how their First Amendment rights were restored. Charles?
Forgive me, one quick comment on that video. Don't you wish they would have just, everybody's in agreement. Like, yeah, George, great idea. We should throw in this whole Article 5 thing. But then they all assumed it would be really easy to get back together someday. Like they would all be on the same page instead of just, hey, how about every 25 years, just automatic Convention of States? But, whatever. I guess they teed it up at least. So, okay. So, yeah. So this comes from SCOTUS blog. After the Parkland shooting in 2018, Maria Vullo, the head of New York's Department of Financial Services, issued a press statement and guidance letters calling on banks and insurance companies to consider the risks to their reputations of doing business with organizations that promote guns. Several insurance companies stopped doing business with the NRA, and some banks withdrew their bids for the group's business. That prompted the NRA to file a lawsuit against Vullo in federal court, arguing that she violated the group's First Amendment right by threatening the companies and banks to sever their ties with the group. The NRA's lawyer argued that informal indirect government efforts to suppress or penalize speech by threatening private intermediaries violates the First Amendment. Vullo's lawyer argued that because guns are illegal, she's in the right. But she's a government official actively suppressing the rights of a company solely because they promote something she doesn't approve of. So, like you said, John, it's a 1A violation of a 2A organization.
Wow.
They unanimously ruled in favor of the NRA. Unanimously.
You use the U word, unanimous.
Mm-hmm.
All 9 of them ruled in
Yes.
favor of the NRA. Doesn't get much better than that.
Yeah.
I like the 6-3. I like 7-2. I like 8-1 even better, but 9-0. Wow.
Mm-hmm.
Okay, Dale or Gary or Debbie, you have any comments or any questions you want to throw to Charlie? Your name is Gary, yes.
I'd just say that the fact that this was a 9-0 decision really does say that the government officials, you cannot be doing this kind of thing. The government should never be using, throwing around its power of influence to try to get other, banks, insurance companies, people like that to not do business with somebody. It's just the fact that it was a 9-0 decision. I think it's very important and very significant.
Yeah, and a big win for liberty. Dale?
Mm-hmm.
Yeah, just another example of government overreach and reining in the control of government.
And speech has been under assault. But for the NRA to have its First Amendment right of free speech restored. 9-0. Powerful stuff. Charles?
It plugs right into the video we just watched. It shows the dark side of regulation, where it even brought up, for anybody who's read 1984, the Department of Education. What's so bad about wanting education? It just the Ministry of Truth. They could never lie. So just because something's governmentally regulated doesn't mean it's not subject to the personal whims of those who control those agencies, which is tyranny. That's exactly what tyranny is. So, anybody in that position is they fully personify the road to hell being paved with good intentions. Maria Bullo thinks she's the good guy. She firmly believes, I'm trying to make the world a better place. I just have to crush freedom of speech as I'm doing it. But, I'm trying to get rid of these nasty guns. That's precisely the brand of tyrant that the founding fathers were trying to avoid and suppress, like straight up suppress. We understand you think you're a good person, but in the grand scheme of things, you're evil. Get out of here.
Okay, Debbie.
Yeah, if you dig down into that actual Parkland school shooting, that was the most amount of people who've ever died. 17 people died, 17 were injured. But if you read what happened, they did the wrong stuff all along the way. They had so many pointers towards this guy. So it's almost like, well, let's blame the guns, right? But if you look at the processes that the police had information, there were several pointers along the way. They even saw him out in the yard. Nobody locked the door. I mean, the whole thing just went awry, and the police didn't really, that whole thing fell apart too. So they didn't really have a process in place. They didn't know who was allowed to call a lockdown, so nobody did. So is it one of those where, well, let's point at this guy over here because we really messed up over here, but let's blame the NRA? Just a thought.
Yeah, administrative failures and looking for a scapegoat. Yes, Charles.
On a related note, my background's in advertising, so I was in Chicago for a long time, big advertising hub. The company I worked for sells everything because it's advertising. All the worst things in the world, everything that gives you cancer, cigarettes and fast food and insurance, all the worst evils in the world, they slang. The only thing they refuse to sell is guns. And they, at one point, they did for a long time. They made a lot of money off of guns, but then that's just that. Even though they're selling all this other evil crud, everybody just feels free to just point out guns as just being inherently bad. And so the funny thing was that they would kind of occasionally, I think like Beretta came through one time, and they were like, this is Charlie. This is our resident Hoosier boy. He'll make commercials for your guns, but it fell through because people are so quick to jump up and just scream about guns, but they look the other way for all this other stuff that's even worse. Fast food kills more people than guns. I don't have those stats on me, but I'm just going to make that assumption. I think heart disease kills more people than anything else, right? So, but no, it's guns. Guns are bad, and even if you're in any position of power, you can do whatever you want. You can subvert the law however you feel because guns are just bad, right?
Oh, yeah, they are. Yeah. That was borne out this morning. I had some time, and so I tuned into the House of Representatives Oversight Committee, where they interviewed the director of the Secret Service. And since COS is a nonpartisan organization, I won't name any political parties, but one side of the aisle was questioning about the shooter, and another side of the aisle was questioning about AR-15s. Should this gun be allowed? And I thought, okay, they found a way to make it political. We were this close to a national tragedy, an inch or less from a national tragedy. And one side of the aisle is worried about the fact that the shooter used an AR-15, and they always called it an AR-15 assault rifle. Yeah. And it's not. I don't own one. I don't think I've ever seen one. I've never touched one, but it is not an assault rifle, So there you have it. Anything else on the NRA issue from anybody around the table?
I had a question for our law expert. Gary.
Mm-hmm.
So I always have questions for him. So how exactly do you tie this into the First Amendment so Maria Vullo, she's not part of the federal government, right? Isn't her boss Governor Cuomo? Which, does that make her a state employee, not a federal employee? So how does that work exactly?
Well, the U.S. Supreme Court basically said that through the application of the 14th Amendment, most of the rights in the Bill of Rights have to be applied not only to the federal government, which is, the amendments specifically apply to the federal government, but by implication, they should also apply to the state governments. And so state action that, takes away your rights to speech is just as big a violation as if the federal government did it. So state governments, most of the things in the Bill of Rights are also applicable to state governments. If the federal government's prohibited from doing it, in most cases, the states are likewise prohibited from doing those same things.
Which is interesting because she argued, hey, I'm just saying guns are illegal here. So, they're the ones breaking the law by, but for them, it's speech. They're not. What the NRA is doing is speech oriented, but she was saying what they're pushing for is illegal. So I'm in the right. And obviously the Supreme Court said, nah.
You could rationalize just about anything if you try hard enough.
Yes.
But state governments, local governments are not allowed to suppress free speech. There you go. There you have it. Well, let's turn the corner and go to our final SCOTUS case. And it's the case in which the court affirmed that every president of the United States is immune from criminal prosecution for official actions undertaken as president. Presidents in the past, the current president, and presidents in the future, immune from criminal prosecution for official actions undertaken as president. Debbie, take us for a walk down this pathway.
Okay, well, this case is called Trump versus the United States, and it started right after January 6th. Trump had 3 separate civil lawsuits slapped against him by either the police or some congressmen, and it was all around the January 6th thing in the District of Columbia. So Trump said, well, hey, I'm immune because I was president at the time. And that passed on to the district court for the District of Columbia. And the judge said, no, you're not. And so she rejected his claim. Well, then it got passed on to the Court of Appeals, and they upheld this judge's opinion. And they said, well, when he was out there speaking on January 6th, he was an office seeker. He was an office holder, but he was giving a campaign speech, supposedly. And so they don't think that immunity should apply. Well, not to continue this thing on, but basically there were more the grand jury indicted Trump, and then he filed to dismiss. It was rejected, then Court of Appeals, then up to the Supreme Court. Okay? Mm-hmm. So that's kind of how it happened, and they agreed to hear the case. And then this was a landmark decision of the Supreme Court in which the court determined that presidential immunity from criminal prosecution, presumptively, meaning presumed in the absence of further information, extends to all of a president's official acts, just like he said. Okay, so what were some of the official acts? The Constitution is very explicit in defining the role of the president. Some of those things would be that Congress cannot regulate the pardoning of people, commanding of the military, execution of laws, control of the executive branch, vetoing legislation, managing immigration, appointing judges. So things like that are very explicit. This case extends from an ongoing federal trial to determine if Donald Trump, at the time, engaged in election interference on January 6th. Interesting, this is the first time a case concerning the criminal prosecution for alleged official acts of a president was brought before the Supreme Court. So the ruling was 6-3. It fell right on ideological lines, and it was ruled on July 1st that number one, Trump had absolute immunity for acts he committed as president within his core constitutional scope of duties. Okay, so that part's easy right there. The second thing, though, at least presumptive immunity for official acts that were kind of like in the outer perimeter of his duties. And then the third thing, he has no immunity for unofficial acts.
Yeah.
And this is for any president. So Biden falls under this same ruling.
Yeah.
So the question now really is, the Supreme Court didn't rule on the scope of the immunity for some of his acts. So now it gets pushed back to the lower courts. And now they have to go through and look at each one of these alleged acts that he did. And they have to determine, was that in the scope? Was that in the perimeter? Was that totally outside of his duties?
Yeah.
A couple cases that there were like 4 cases they used, but 2 of the main ones was Nixon versus Fitzgerald, which was in 1982, where the Supreme Court said the president is immune from civil suit for money damages in regard to official acts. So that played into that ruling. And then the second main case was the United States versus Nixon in 1974, and Trump versus Vance. That's kind of funny. In 2020, which limits the president's privilege within the judicial process. Like so that at that point, John Roberts, Chief Justice Roberts, said that the president is not categorically above the common duty to produce evidence when called upon in a criminal proceeding. So, what does that mean for us now? We talked about the 3 levels. So now it's going to be the lower courts. They're going to have to go through and review every one of these actions, right? Were they public? Were they private? And it's going to take a while. So most likely it's not going to happen before November 5th. And the ruling might require some allegations to be stripped from the indictment, a process with the lower courts that could take several months also.
Yeah.
Also, a absolute immunity does not extend into areas where there are authority is shared with Congress. I thought that was interesting.
Mm-hmm.
So, and I said, as his unofficial acts, there's no immunity. So I felt like this was a fair ruling because, you know, as a president, they do a lot of things like, you know, if they're commanding the military and they mess up, you can't hold that against them. That was their core duty. You can't do a perfect job. But at the same time, though, those acts that are done outside you can actually be, you know, taken through court for those.
Mm-hmm.
So, yeah.
Okay. Another big win for liberty. Now, I don't suppose anyone within the sound of my voice is ever going to be the president of the United States, but it's good to know that the Supreme Court said, hey, Mr. or Mrs. President, when you do something within the scope of your official duties as president, you cannot be charged criminally for that. In fact, the Constitution has a remedy for that for high crimes and misdemeanors. It's called impeachment, and that's a rare thing. The House has impeached a few times, not a lot of times, but a few times, and that's the remedy, not the criminal court. You know, if a president does wrong within the scope of the job, there's a remedy. Okay, I'm going to turn to the rest of the roundtable now. Gary, Charles, Dale, I see that hand.
I thought that the Supreme Court sent this back to the lower courts so that they could define what's a non-presidential official act.
Yeah.
What is and what isn't.
Yeah, I think Debbie said that. Yeah.
Did you?
Yeah, I mean, there are certain ones that are spelled out in the Constitution. Those are not going to be questioned. But there will be other ones that they're going to have to go through each one of those acts. And each
those cases they're going through, or are those acts that you?
No, I would say acts that he did the things that they're allegedly accusing him of, were those within his core duties? Were they in the perimeter, or were they unofficial acts? They have to go back now and label each one of those.
So specifically the ones that he's been accused of.
Yes.
Okay, I'm thinking of I'm thinking of general definitions of what's an official act and what's a non-official act is what I'm thinking.
I'm trying to remember if they actually defined what those were, or if they I know they defined what his official acts were, most of those, because they're right in the Constitution.
Mm-hmm.
The rest of them, I did not see that they actually defined that, although I did read that his alleged efforts to leverage the Department of Justice in producing alternate states of electors could not be prosecuted while sending back decisions on immunity related to alleged pressuring of the vice president, state official, and private individuals to the district court. So I think they're still working through these things. The Supreme Court kind of backed off of labeling everything.
Yeah.
Well,
In my opinion,
I think it's a good thing that some definition comes out of this as to what's really considered non-official.
Yeah.
I think I do think that's important, but okay.
And the way I look at it, of course, I'm not an attorney, but the way I look at it, the Supreme Court was saying to the lower court, you didn't do your job. Now you get to do your job. Sort these things out and then move forward. Charles.
I just need clarification. If Trump did shoot somebody on Fifth Avenue, could he be prosecuted?
Yeah, that's interesting because it said in there about that if you assassinate, if you weaponize against your opponent, you can't get in trouble for that. So I thought that was interesting. That's a question mark, I should say.
That's what the left is accused. That's what the left is saying.
Well, look at what Joe Biden's been doing to his opponent. Like, so, yeah.
Yep. Okay, Gary, any final thoughts on this before we run out of time?
I want to go back for just a minute to the overturning the Chevron doctrine. Charlie asked how this came up, and just a very quick, the federal government regulates commercial fishing, and they not only put monitors on commercial fishing boats, they decided that their power extended to forcing the fishing companies to pay for the guys who were on there monitoring their fishing. And so the agencies just saying, we can not only put people on there, we can make you pay for it. And the Supreme Court said, hey, no, wait a minute. Unless that's specifically in the statute, you can't do that. And that was a good thing. That's a win for liberty, for sure.
So that's how that came about. Okay, Dale, was your hand up?
No.
Okay, you were just resting it. Okay.
Yes, I'm done.
Well, that brings us to the end of this month's roundtable. Before we close it out, I want to give you our email address. If you have any questions about Convention of States, anything at all, you can email them to us at this address, raiseyourvoice.cos@gmail.com. That's raiseyourvoice.cos@gmail.com. And I want to invite you to be sure to tune in a week from tonight, next Monday, July 29th at 7 p.m. Eastern, for our next COS Indiana Live. And Dale's going to tell us a little bit more about J6 prisoner Jeremy Brown's appearance.
Yes, this is, I'll be very brief here, but this is going to be a special report for us on the 29th. We're going to kick off a new series that we've started. It's called Pillars of Freedom. And with a January 6th advocate, Wendy Olson, and she's going to be bringing us cases and individuals that have been caught up in the January 6th fiasco. And we're going to start off on the 29th with a phone interview with an actual prisoner who's serving time in Florida. His name's Jeremy Brown. And he's got quite a unique story, but we're hoping that he also has quite a bit of experience and knowledge about what happened on January 6th. So we're gonna pick his brain and hopefully learn some things about January 6th. May take a couple interviews to get everything, but tune in next Monday, July 29th.
Yeah, I'm looking forward to that. I'm not always available on the 4th or whatever it is. It's the 5th. It's the 5th Monday. Tonight is the 4th Monday.
Yes, it is. That is
yeah.
Right. Well, of course, it's all of them are recorded. So
and that's where I was going with that. The ones that I can't watch live, I catch the recordings quite often. So then the next roundtable will be on the 4th Monday of August. That'll be 26th, August 26th, and we'll figure out a topic between now and then. It's at 7 p.m. Eastern Time. And now to close us out, here's episode number 10 of COS Basics, and it's called Grassroots Engagement. John Ackerman for Convention of States, Indiana. This is number 10 in our series of COS Basics, and the topic this time is grassroots engagement. The whole idea here is Convention of States is a national movement, and so what can one person like you or me do on a local level to make a difference? And so I have a few suggestions today how you can get involved in grassroots engagement. First of all, and perhaps most important, is to volunteer to become a district captain. Every state in the union is divided into legislative districts, and we need a district captain in every one of those. Now, don't worry, if your district already has a captain, and if you're good enough, just joking, you can be a captain of a nearby district. Just start the application process and get involved with your state director. Another way you can get involved on the grassroots level is to become a state leader. We need region captains. I can talk. We need legislative liaisons. We need follow-up team members, and on and on and on. We have all kinds of state-level positions that are open, probably in every one of the 50 states. And you can be a volunteer activist. You can do block walking. You can set up a COS booth at a local event, a farmer's market or something like that. You can take COS university courses to learn about Article 5 and the Convention of States. To do that, just go to cosuniversity.com, and there you'll be amazed at the array of free classes that you can take. Just the first four I'll name. I don't have time to name all of them, but there is an introduction to Convention of States. There's an introduction to volunteering. There's a course on responding to opposition, and believe you me, there's plenty of opposition. And there's a course on constitutional literacy. Yeah, I'm having trouble talking today. Constitutional literacy. So those are just the first four courses, and there's a slew of others. There's as much learning there as you have time to do. And you can also attend the Tuesday training webinar that's held every Tuesday at 9 p.m. Eastern Time, or you can view recordings of the past webinars. You can watch Mark Meckler's Battle Cry on Sunday nights at 8 p.m. Eastern Time on the COS Facebook page. You can watch COS live Tuesday evenings, 6 p.m. on the COS Facebook page. You can spend some time on our website, conventionofstates.com, learning about COS so that you're comfortable discussing the basics of Article 5. You can sign up to attend a Constitution class with Mark Meckler and Rick Green. You can attend a local government, school board, or political party meeting to observe and learn about what's going on in your area. There's no end to the things you can do to get involved on the grassroots level to promote Convention of States. Oh yeah, you want to get involved on the grassroots level? We got you covered.